Introduction to Notary Public Role. A notary public serves as an impartial witness to the signing of important documents and administers oaths and affirmations. This role is crucial for preventing fraud and ensuring the authenticity of signatures on legal and financial instruments. Notaries are public servants appointed by state governments, holding a position of trust and responsibility. Their primary duty is to protect the public from fraudulent acts. Maintaining the integrity of various transactions. Understanding this foundational role is the first step toward becoming a certified notary. The responsibilities are significant, requiring diligence and adherence to strict legal guidelines. The authority of a notary public is derived from state law, meaning the specific powers and duties can vary significantly from one state to another. This course will highlight these jurisdictional differences, providing a comprehensive guide for certification across the United States. Notaries play a vital role in countless transactions, including real estate deeds, loan documents, powers of attorney, and affidavits. Their presence ensures that the individuals signing these documents are indeed who they claim to be and are doing so willingly. This impartial verification process underpins the reliability of many legal processes. Understanding notary responsibilities. Notaries are entrusted with several critical responsibilities, primarily to act as an impartial witness. This impartiality means a notary must not have any personal interest in the transaction or benefit from the outcome of the document being notarized. They must verify the identity of the signer, ensuring they are the person named in the document. This often involves examining government-issued identification documents. Furthermore, notaries must ensure the signer appears willing and aware of the document's contents, preventing coercion or fraud. These duties form the core of a notary's ethical and legal obligations, safeguarding the public interest. Adherence to these principles is paramount for maintaining the integrity of the notarial act. Another key responsibility is to maintain accurate records of all notarial acts performed. Most states require notaries to keep a journal detailing each notarization, including the date, type of act, document title, signer's name, and identification used. This journal serves as a vital record for legal inquiries and protects both the notary and the public. Notaries must also administer oaths and affirmations truthfully and solemnly, ensuring the person taking the oath understands its gravity. These responsibilities demand meticulous attention to detail and a thorough understanding of state-specific regulations. Proper execution of these duties builds public trust in the notarial system. Key principles of notarial acts. Several fundamental principles underpin all notarial acts, ensuring their validity and legal standing. Impartiality is paramount. A notary must never act in a situation where they have a personal interest or financial gain. This strict neutrality protects all parties involved in a transaction. Verifying the signer's identity is another core principle, typically requiring current, government-issued photo identification. The notary must be satisfied that the person appearing before them is indeed the individual named in the document. This process is critical for preventing identity theft and document fraud. Understanding and upholding these principles is essential for every notary. The principle of personal appearance dictates that the signer must physically appear before the notary at the time of the notarization. This allows the notary to verify identity, observe the signer's willingness, and administer any required oaths or affirmations directly. While remote online notarization, RON, has introduced exceptions, the core principle of direct interaction remains foundational in traditional notarization. Notaries must also ensure the signer is acting voluntarily and is aware of what they are signing, assessing their comprehension and freedom from duress. These principles collectively uphold the integrity and trustworthiness of the notarial system, making documents legally sound. Jurisdictional differences, state laws. The United States operates under a system where notary public commissions are granted by individual states, leading to significant jurisdictional differences in laws and procedures. Each state has its own statutes governing notary eligibility, application processes, required training, and authorized notarial acts. For example, some states mandate a notary exam, while others do not. The specific types of identification acceptable for signer verification can also vary. Aspiring notaries must thoroughly research and understand the laws of the state in which they intend to be commissioned, as compliance with these specific regulations is non-negotiable. Ignorance of state law is not a valid defense for improper notarial acts. These state-specific variations extend to the types of notary bonds or errors and omissions, E&O insurance required, the design of the notary seal, and record-keeping mandates. Some states may require a specific format for the notary journal, while others offer more flexibility. Furthermore, the rules regarding remote online notarization, RON, and electronic notarization differ widely, with some states having robust frameworks and others still developing their regulations. Navigating these diverse legal landscapes requires careful attention to detail and a commitment to continuous learning. This course will provide strategies for researching and understanding these crucial state-specific requirements, ensuring compliance. Eligibility requirements. General overview. While specific eligibility requirements vary by state, several general criteria are common across most jurisdictions for becoming a notary public. Applicants must typically be at least 18 years old, demonstrating legal adulthood and the capacity to enter into contracts. A fundamental requirement is legal residency in the state where the commission is sought. Though some states may allow non-residents who work within the state, applicants must also be able to read, write, and understand the English language, as notarial acts often involve complex legal documents. These basic qualifications ensure that potential notaries possess the foundational abilities necessary for the role. Meeting these general criteria is the initial hurdle in the certification process. Another common requirement is a clean criminal record. Most states prohibit individuals with felony convictions or certain misdemeanor convictions from becoming a notary, reflecting the position of trust involved. Applicants may be required to disclose any past convictions, and a background check is often part of the application process. Some states also require applicants to be a citizen or legal resident of the United States. While not universally mandated, a high school diploma or GED is often implicitly expected due to the nature of the duties. Understanding these general eligibility requirements helps individuals determine their readiness to pursue a notary commission. Each state's specific laws will provide the definitive list of qualifications. Specific state requirements. Research. Given the significant jurisdictional differences, thorough research into specific state requirements is an indispensable step for aspiring notaries. The official website of the Secretary of State or the equivalent commissioning agency in your state is the most reliable source of information. These websites typically provide detailed guides, application forms, and current statutes pertaining to notary commissions. It is crucial to review these resources carefully, paying close attention to residency rules, age limits, educational mandates, and any criminal history restrictions. Relying on outdated or unofficial information can lead to delays or rejection of your application. Proactive and accurate research streamlines the entire certification process. Beyond basic eligibility, state-specific research must also cover training requirements, examination procedures, and bonding/insurance mandates. Some states require approved notary education courses, while others may only recommend them. The format and content of notary exams vary widely, from open book online tests to proctored in-person examinations. Understanding these nuances is vital for adequate preparation. Additionally, investigate the specific types of notary seals, journals, and other supplies approved or required by your state. Creating a checklist of all state-specific requirements will help ensure no critical step is overlooked, paving the way for a successful application and commission. Application process. Initial steps. The initial steps of the notary application process typically involve obtaining and completing the official application form from your state's commissioning authority, usually the Secretary of State. This form will require personal information, including your legal name, address, contact details, and sometimes your social security number. It is crucial to fill out the application accurately and completely, as any errors or omissions can lead to delays or rejection. Pay close attention to instructions regarding notarization of your own signature on the application, if required. Some states may also ask for references or a brief statement of intent. Double-checking all entries before submission is a best practice. Along with the completed application form, you will almost certainly need to submit an application fee. The fee amount varies by state and is non-refundable, so ensure you meet all eligibility criteria before paying. Some states may also require you to submit proof of residency, such as a utility bill or driver's license copy. A background check is part of the process. You might be directed to a specific vendor for fingerprinting or to complete a separate authorization form. Understanding these initial submission requirements and gathering all necessary documents beforehand will make the application process smoother and more efficient, setting a positive tone for your notary journey. Notary education and training. Many states require or strongly recommend specific education and training for aspiring notaries. This training ensures that notaries understand their legal obligations, the various types of notarial acts, and the importance of ethical conduct. Courses often cover topics such as identifying signers, preventing fraud, maintaining a notary journal, and understanding state-specific laws. The format of these educational programs can vary, including online courses, in-person workshops, or self-study materials. Completing an approved education course can significantly improve an applicant's chances of passing a notary exam and performing their duties competently. It is a critical investment in professional development and public trust. Some states, like California and Florida, have mandatory education requirements, specifying the number of hours of instruction needed. These courses are typically offered by state-approved vendors or educational institutions. Even in states where education is not mandatory, enrolling in a reputable notary training program is highly advisable. Such programs provide invaluable practical knowledge and insights that go beyond simply reading the statutes. They often include scenarios and case studies that prepare notaries for real-world situations. Proper training equips notaries with the confidence and knowledge to execute their duties accurately and ethically, minimizing risks for both themselves and the public they serve. Passing the notary exam if required. In several states, passing a notary exam is a mandatory step to obtain a commission. This examination assesses an applicant's understanding of state notary laws, ethical principles, and proper notarial procedures. The format and difficulty of these exams vary significantly by state. Some states offer open book online exams, while others require proctored, in-person tests with strict time limits. Thorough preparation is essential, which typically involves studying the state's notary handbook or statutes and completing an approved notary education course. A passing score demonstrates competency and readiness to perform notarial duties responsibly. Failing the exam often means a waiting period before retesting, so first attempt success is desirable. Effective study strategies for the notary exam include reviewing all provided state materials, taking practice tests, and focusing on areas where state laws differ from general notary practices. Understanding the legal definitions of various notarial acts, acceptable forms of identification, and prohibited acts is crucial. Many state commissioning authorities provide study guides or outlines of topics covered on the exam. It is important to familiarize yourself with these resources. The exam is designed to ensure that only qualified individuals who fully comprehend their duties and limitations are commissioned, thereby protecting the public. Adequate preparation is the key to confidently passing this critical hurdle in the certification process. Background checks and fingerprinting. Given the position of public trust held by a notary public, most states require applicants to undergo a criminal background check. This process typically involves submitting fingerprints, which are then used to search state and federal criminal databases. The purpose is to ensure that individuals commissioned as notaries do not have a history of crimes that would compromise their integrity or suitability for the role, particularly those involving fraud, dishonesty, or moral turpitude. Specific instructions for fingerprinting, including approved vendors and submission procedures, are provided by the state's commissioning authority. It is essential to follow these instructions precisely to avoid delays in the application process. A clean background is a prerequisite for public service roles like a notary. The results of the background check are usually sent directly to the commissioning agency. Any disqualifying convictions, as defined by state law, will typically lead to the denial of a notary commission. Some states may have provisions for applicants to appeal a denial or provide additional information regarding past convictions, but this varies. It is advisable for applicants with any past criminal history to review their state's specific guidelines regarding disqualifying offenses before applying. The background check process underscores the importance of public trust and the need for notaries to be individuals of unquestionable character. This step is a critical safeguard in maintaining the integrity of the notarial system. Notary bond and errors and omissions insurance. Most states require notary public applicants to obtain a notary bond as a prerequisite for commissioning. A notary bond is a type of surety bond that protects the public from financial harm caused by a notary's misconduct or negligence. It is not insurance for the notary, but rather a guarantee that if a notary causes financial damage through their official acts, the bond will cover the losses up to the bond amount. The required bond amount varies significantly by state, ranging from a few $1,000s to tens of thousands. Purchasing a notary bond is a crucial step that ensures financial recourse for the public in case of notary errors. This requirement underscores the serious nature of the notary's responsibilities. While a notary bond protects the public, errors and omissions (E&O) insurance protects the notary. E&O insurance covers legal expenses and damages that a notary might incur if sued for an honest mistake or omission made during a notarial act. Although E&O insurance is typically optional, it is highly recommended for all notaries. Even with the utmost care, mistakes can happen, and the financial implications of a lawsuit can be substantial. Having E&O insurance provides peace of mind and financial protection against potential liabilities. Notaries should carefully consider the coverage limits and terms of any E&O policy to ensure adequate protection for their specific practice. Obtaining notary supplies, seal, and journal. Once commissioned, notaries must obtain the necessary supplies to perform their duties legally and effectively. The most critical supply is the notary seal or stamp. State laws dictate the specific requirements for the seal, including its shape, circular or rectangular. The information it must contain, e.g., notary's name, commission number, expiration date, state of commission, and whether it must be an embosser or an ink stamp. It is crucial to purchase a seal that strictly adheres to your state's specifications, as an improper seal can invalidate notarial acts. Reputable notary supply vendors are the best source for compliant seals. The seal is the official mark of a notary's authority. Another indispensable notary supply is the notary journal or record book. Most states mandate that notaries maintain a journal to record every notarial act performed. The journal serves as a chronological log, providing a detailed account of each transaction, including the date, type of act, document title, signer's name, and the type of identification used. This record-keeping is vital for protecting both the notary and the public, offering evidence in case of legal disputes or inquiries. Some states specify the format or content of the journal, while others allow for more flexibility. Selecting a durable, tamper-proof journal is important for long-term record retention. Proper use and safeguarding of the journal are paramount for ethical notary practice. Taking the oath of office. A pivotal step in becoming a commissioned notary public is taking the oath of office. This solemn declaration signifies the notary's commitment to faithfully and impartially discharge the duties of their office according to the law. The specific wording and procedure for taking the oath are prescribed by state law. In many states, the oath must be administered by another commissioned notary, a judge, or a court clerk. This act is often part of the final commissioning process, formally recognizing the individual's authority to act as a public official. It is a moment of significant responsibility, marking the transition from applicant to commissioned notary. Understanding the gravity of this oath is crucial for ethical practice. After the oath is administered, it is typically recorded and filed with the appropriate state or county office. This filing makes the notary's commission official and publicly verifiable. Some states may require the oath to be taken and filed within a specific time frame after receiving notification of approval, so adherence to deadlines is important. The oath of office serves as a constant reminder of the notary's obligations to uphold the law, maintain impartiality, and protect the public. It reinforces the ethical foundation upon which all notarial acts are built. This formal commitment is a cornerstone of the notary's role, ensuring accountability and trustworthiness in their public service. Commissioning and filing documents. Upon successful completion of all application requirements, including background checks, exams, and bonding, the state commissioning authority will issue your notary public commission. This official document grants you the legal authority to perform notarial acts within your state. It typically includes your name, commission number, and the effective and expiration dates of your commission. It is crucial to review your commission certificate for accuracy immediately upon receipt. This document is your proof of authority and should be kept in a safe, accessible place. Understanding the details of your commission is vital for legal compliance and proper execution of duties. Following the issuance of your commission, some states require additional filing steps at the county level. This might involve filing your oath of office, your notary bond, or a copy of your commission certificate with the county clerk's office in your primary place of business or residence. These county-level filings ensure that your commission is registered locally and publicly accessible within your operational area. Failure to complete these final filing steps can invalidate your commission or delay your ability to perform notarial acts. Always consult your state's specific instructions regarding county filings and adhere to any prescribed deadlines. Proper filing ensures your commission is fully active and recognized by all relevant authorities. Maintaining your notary commission. Obtaining a notary commission is just the beginning. Maintaining it requires ongoing diligence and adherence to state laws. Notary commissions are typically valid for a specific term, ranging from 4 to 10 years, depending on the state. It is the notary's responsibility to be aware of their commission expiration date and to initiate the renewal process well in advance. Renewing a commission often involves a similar process to the initial application, including updated background checks, education, and sometimes an exam. Failing to renew on time can lead to a lapse in commission, requiring a complete reapplication and potentially preventing you from performing notarial acts. Proactive management of your commission status is essential. Beyond timely renewal, maintaining your commission also involves staying informed about changes in state notary laws. Legislatures can amend statutes, introduce new regulations, or update existing procedures, and notaries are expected to remain compliant. Subscribing to updates from your state's commissioning authority or notary associations can help you stay current. Additionally, maintaining accurate and secure notary records, including your journal and seal, is a continuous responsibility. Ethical conduct and professional behavior in all notarial acts are paramount. A notary's reputation for trustworthiness and competence is built on consistent adherence to legal and ethical standards throughout their commission term. Continuous learning and compliance are key to a successful notary career. Understanding notarial fees. States typically regulate the maximum fees a notary public can charge for performing notarial acts. These fees are set by statute and are designed to be reasonable, ensuring public access to notary services while compensating the notary for their time and expertise. It is crucial for notaries to be aware of and strictly adhere to these prescribed fee schedules. Charging more than the maximum allowed fee is a violation of state law and can lead to disciplinary action, including fines or suspension of your commission. Notaries should clearly communicate their fees to clients before performing any service to avoid misunderstandings. Transparency in pricing builds trust and ensures compliance. In addition to the statutory fee for the notarial act itself, notaries may also be permitted to charge for travel expenses. However, these travel fees are usually separate from the notarial fee and must also comply with state guidelines, which may include mileage rates or a flat travel fee. Some states require a separate written agreement for travel fees. It is important to distinguish between the notarial fee and any additional charges for services like travel or printing. Notaries should keep accurate records of all fees charged. Understanding and correctly applying the state's fee schedule is a fundamental aspect of ethical and legal notary practice, protecting both the notary and the public from unfair charges. Types of notarial acts. Acknowledgements. An acknowledgement is one of the most common types of notarial acts. In an acknowledgement, the signer personally appears before the notary, identifies themselves, and declares that they have willingly signed the document. The notary certifies that the signer's identity was verified and that the signer voluntarily executed the document. The notary does not certify the truthfulness or legality of the document's contents, only the authenticity of the signature and the signer's intent. This act is frequently used for real estate documents, such as deeds and mortgages, where it is essential to confirm that the person conveying property is indeed the owner and is doing so without coercion. Understanding the specific requirements for an acknowledgement is fundamental for any notary. The key elements of an acknowledgement include the signer's personal appearance, proper identification, and a verbal declaration by the signer. The notary then completes a notarial certificate, which is a written statement attached to or included within the document, attesting to the performance of the notarial act. This certificate typically includes the date, location of the notarization, the notary's name, and their official seal. It is crucial that the notary does not advise the signer on the legal implications of the document, as this would constitute the unauthorized practice of law. The notary's role is strictly limited to witnessing the signature and verifying identity. Proper execution of an acknowledgement ensures the legal validity of many important documents. Types of notarial acts. Jurats. A jurat is another common notarial act, distinct from an acknowledgement, where the notary administers an oath or affirmation to the signer regarding the truthfulness of the document's contents. In a jurat, the signer must personally appear before the notary, identify themselves, and then swear or affirm that the statements in the document are true. The notary then witnesses the signer's signature on the document. Unlike an acknowledgement, where the notary only verifies the signature's authenticity, a jurat involves the notary certifying that the signer took an oath or affirmation and signed the document in the notary's presence. This act is frequently used for affidavits, depositions, and other sworn statements. Understanding this distinction is crucial for proper notary practice. Key components of a jurat include the signer's personal appearance, proper identification, the administration of an oath or affirmation by the notary, and the witnessing of the signer's signature. The notarial certificate for a jurat will explicitly state that the document was subscribed and sworn to or affirmed before me. The notary's role is to ensure the oath is properly administered and that the signer understands the gravity of swearing to the truthfulness of the document. As with all notarial acts, the notary must remain impartial and cannot offer legal advice. The proper execution of a jurat adds a layer of legal solemnity to documents where the truthfulness of statements is paramount, making it a critical tool in legal proceedings. Types of notarial acts. Oaths and affirmations. Oaths and affirmations are notarial acts where the notary administers a solemn verbal pledge to an individual. An oath is a solemn promise to God or a sacred entity that one's statements are true or that one will faithfully perform a duty. An affirmation is a similar solemn pledge, but without religious reference, typically for those who object to swearing an oath for religious or personal reasons. In both cases, the individual must personally appear before the notary, identify themselves, and then verbally make the pledge. The notary's role is to administer the oath or affirmation, ensuring the individual understands its gravity and is making the pledge voluntarily. This act is often performed for witnesses testifying in court or for individuals making sworn statements. The notary does not certify the truthfulness of the statement itself, but rather certifies that the oath or affirmation was properly administered to the identified individual. The notarial certificate for an oath or affirmation will typically state that the individual personally appeared before me and took an oath or affirmation. It is crucial that the notary uses the correct wording for the oath or affirmation as prescribed by state law or the requesting entity. Notaries must never force an individual to take an oath if they prefer an affirmation or vice versa. This respect for individual beliefs is part of the notary's impartiality. These acts are fundamental for adding legal weight to verbal declarations, ensuring accountability in various legal and administrative contexts. Types of notarial acts. Copy certifications. Copy certification is a notarial act where the notary certifies that a copy of an original document is a true, exact, complete, and unaltered reproduction of the original. This act is only permissible for certain types of documents, and state laws vary significantly on what documents a notary can certify copies of. Typically, notaries can only certify copies of documents that are not publicly recordable, e.g., a diploma or a medical record, and for which the notary personally made or supervised the making of the copy. Notaries generally cannot certify copies of vital records, birth certificates, marriage licenses, or documents that can be obtained from a government agency, as these are typically certified by the issuing agency. Understanding these limitations is critical to avoid illegal notarial acts. To perform a copy certification, the original document must be presented to the notary. The notary will then make or supervise the making of the copy, ensuring it is an exact replica. The notary then completes a notarial certificate for copy certification, attesting to the accuracy of the copy. This certificate will typically state that the notary verified the copy against the original. It is crucial for notaries to strictly follow their state's guidelines regarding copy certifications, as this is an area prone to errors if not handled correctly. When in doubt, a notary should always advise the client to seek a certified copy from the issuing agency, rather than attempting to perform an unauthorized copy certification. Proper execution ensures the integrity of reproduced documents for legal and administrative purposes. Identifying signers, acceptable IDs. Properly identifying signers is perhaps the most critical duty of a notary public, as it prevents fraud and ensures the integrity of the notarial act. State laws dictate what constitutes acceptable forms of identification. Generally, notaries must rely on current, government-issued identification documents that contain a photograph, a physical description, and a signature. Common examples include a state-issued driver's license or identification card, a U.S. passport, or a foreign passport stamped by U.S. Citizenship and Immigration Services. The ID must be unexpired, or, in some cases, expired within a certain time frame as permitted by state law. Notaries must carefully examine the ID for signs of tampering or alteration and compare the photo and description to the signer's appearance. This meticulous verification is a cornerstone of fraud prevention. Beyond standard government-issued IDs, some states allow for identification based on the personal knowledge of the notary, or through the sworn testimony of one or two credible identifying witnesses. Personal knowledge means the notary has known the signer for a sufficient period to be certain of their identity. Credible identifying witnesses by individuals who personally know the signer, are known to the notary, and swear or affirm to the signer's identity. These alternative methods are typically used when a signer lacks traditional identification. However, notaries must strictly adhere to their state-specific rules for these methods, as they carry higher risks. When in doubt, always request a primary government-issued photo ID. The notary's vigilance in identifying signers is paramount to upholding public trust. Refusing notarial service. Valid reasons. A notary public has the right, and sometimes the obligation, to refuse notarial service under specific circumstances. Understanding valid reasons for refusal is crucial for ethical and legal notary practice. One primary reason is if the signer fails to provide satisfactory identification, as required by state law. If the notary cannot confidently verify the signer's identity, they must refuse the service to prevent fraud. Another valid reason is if the notary suspects the signer is not acting voluntarily, appears to be under duress, or does not understand the document they are signing. The notary's role includes ensuring the signer is willing and aware, and any doubt in this regard warrants refusal. Refusing service in these situations protects both the public and the notary from potential legal repercussions. Further valid reasons for refusal include if the document is incomplete or appears altered, or if the notary has a personal interest in the transaction. Notaries must not notarize documents where they are a party to the transaction or would benefit from its outcome. If the notary is asked to perform an illegal notarial act, such as backdating a document or notarizing a signature not made in their presence, unless specifically allowed by RON laws, they must refuse. Notaries are not required to provide legal advice, and if a signer requests such advice, the notary should refuse and direct them to an attorney. Documenting the refusal in the notary journal, including the reason, is a recommended best practice. Exercising the right to refuse service responsibly upholds the integrity of the notarial office. Record keeping. Notary journal best practices. Maintaining a detailed and accurate notary journal is a cornerstone of responsible notary practice and is mandatory in most states. The journal serves as a chronological record of every notarial act performed, providing crucial evidence in case of legal disputes or inquiries. Best practices for journal keeping include recording the date and time of each act, the type of notarial act, e.g. acknowledgement, jurat, the title or description of the document, the signer's name and address, the method of identification used, and the fee charged. Some states also require the signer to sign the journal entry themselves. Consistency and completeness in these entries are paramount. A well-maintained journal protects both the notary and the public. Beyond the content of the entries, the physical security of the notary journal is equally important. Notaries should keep their journal in a secure location, such as a locked drawer or safe, to prevent unauthorized access or tampering. It is a confidential document that must be protected from loss or theft. If a journal is lost or stolen, the notary must immediately report it to the commissioning authority and potentially law enforcement. When a notary's commission expires or is resigned, state laws dictate the proper disposition of the journal, often requiring it to be delivered to the county clerk or another designated official. Adhering to these best practices ensures that the notary journal remains a reliable and protected record throughout its life cycle, upholding the integrity of the notarial system. Remote online notarization. Overview. Remote online notarization, RON, allows notaries to perform notarial acts for signers who are not physically present, using audio-visual technology over the internet. This modern approach to notarization has gained significant traction, especially in recent years, offering convenience and accessibility. However, RON is not universally permitted. Each state must pass specific legislation authorizing its notaries to perform RON, and the rules vary widely. Notaries interested in offering RON services must first be commissioned in a state that allows it and then complete any additional training or registration requirements mandated by their state. Understanding the legal framework for RON is essential for compliant practice. The RON process typically involves several key technological components and security protocols. These include identity proofing through knowledge-based authentication, KBA, and credential analysis of the signer's identification, secure audio-visual communication, and tamper-evident electronic seals and journals. The notary must be physically located in their commissioning state during the RON session, even if the signer is in a different location. The electronic document is signed digitally, and the notary applies an electronic seal and signature. RON offers significant benefits in terms of efficiency and reach, but it also demands a high level of technological proficiency and strict adherence to enhanced security measures. Notaries must ensure they use state-approved RON platforms and maintain robust cybersecurity practices to protect all parties involved. Ethical conduct and professionalism are paramount for every notary public. Notaries hold a position of public trust, and their actions must always reflect impartiality, integrity, and diligence. This means never performing a notarial act for personal gain or in situations where there is a conflict of interest. Notaries must treat all signers with respect and courtesy, regardless of their background or the nature of the document. Maintaining confidentiality of signer information is also a critical ethical obligation. A notary's reputation is built on their unwavering commitment to these ethical principles, which are often codified in state notary laws and professional guidelines. Upholding these standards protects the public and the integrity of the notarial office. Professionalism extends beyond ethical principles to include competence and adherence to best practices. Notaries should continuously educate themselves on changes in state law and best notarial procedures. They should present themselves in a professional manner, be punctual for appointments, and maintain an organized and efficient workspace. Avoiding the unauthorized practice of law, such as giving legal advice or preparing legal documents, is a fundamental aspect of professionalism. When faced with an unfamiliar document or situation, a professional notary will research the relevant state laws or respectfully decline service if they cannot perform the act competently and legally. A commitment to ethical conduct and ongoing professionalism ensures that notaries provide reliable and trustworthy service to their communities. Continuing education and resources. The field of notary public is dynamic, with laws and best practices evolving over time. Therefore, continuing education is highly recommended and in some states mandatory to maintain a current and competent commission. Notaries should actively seek out opportunities to update their knowledge, whether through state-approved courses, webinars, or professional notary associations. These educational resources often cover legislative changes, new technologies like RON, and common pitfalls to avoid. Staying informed ensures that notaries can adapt to new requirements and continue to perform their duties accurately and legally. A commitment to lifelong learning is a hallmark of a truly professional notary. Beyond formal education, a wealth of resources is available to support notaries in their practice. State commissioning authorities typically provide comprehensive notary handbooks, online FAQs, and contact information for inquiries. Professional notary associations, such as the National Notary Association, NNA, offer extensive training, supplies, and legal support. Online forums and communities provide platforms for notaries to share experiences and seek advice. Leveraging these resources can help notaries navigate complex situations, resolve uncertainties, and enhance their overall competence. Proactive engagement with continuing education and available resources empowers notaries to excel in their role and confidently serve the public.